In this video, we're going to be talking about certainty of subject matter. And we've already mentioned in the previous videos that there are three certainties required for the creation of a valid express trust. And we've already looked at one of those certainties, and that is that the settlor must demonstrate a clear intention to create a trust, as opposed to creating something else. So this video is the second intention, and that is certainty of subject matter. So in order for a trust to be formed, there must be certainty as to which property is and which is not covered by the trust. The underlying principle is that a trust to be valid must be enforceable. If there is uncertainty as to the property held on trust, then a court cannot enforce the settlor's wish or the trustee's obligations. The requirement of certainty of subject matter is a requirement that the property which is intended to constitute the trust fund is segregated from all other properties so that its identity is sufficiently certain. If the trust fund is not sufficiently segregated, with the result that there is no certainty of subject matter, then the trust will fail. Okay? The problem of certainty of subject matter therefore relates to the problem of identifying the property that constituted the trust fund. It is important that if there are to be property rights and responsibilities over a trust fund, that fund must be identifiable, or else it would not be possible for the court to know which property is to be administered in accordance with the terms of the trust. Okay. And in Morris and the Bishop of Durham, Lord Eldon said that as it is a maxim that the execution of a trust shall be under the control of the court, it must be of such a nature that it can be under that control, so that the administration of it can be reviewed by the court, or if the trustee dies, the court itself can execute the trust, and therefore, which in the case of maladministration could be reformed. And a due administration directed, and then, unless the subject and the objects can be ascertained upon principles familiar in other cases, it must be decided that the court can neither reform maladministration nor direct a due administration. So this says, as I mentioned, that the trust fund must be identifiable, otherwise it would not be possible for the court to know which property is to be administered in accordance with the terms of the trust. If the court cannot ascertain the subject and objects of the trust, the court will be unable to administer the trust and making it void. Now, in most cases, it will be obvious what is meant when the testator says, I leave my first edition of Harry Potter to be held on trust for my husband. Okay, assume the testator had only one copy of that book, then both his intention to create a trust and the property which was intended to be held on trust will be obvious. This would not be so if he had, more than one first edition copy of Harry Potter. If there were two copies of that book, and it was clear the settlor only intended for one of them to be held on trust, then it would be necessary for the settlor to identify which copy was to be settled on trust and which copy was to remain absolutely her own. If the settlor failed to identify which copy was to be held on trust and which copy was to remain hers absolutely, then there would be uncertainty as to which property was to be held on trust, and therefore the trust would fail. So it will be necessary for the settlor to demonstrate an intention to create a trust, and then also an intention to create a trust over specified property. Okay, and where the property is expressed in vague or uncertain terms, the trust will generally be held to be invalid. So let's have a look at this case of Spungen Barnard. It was said, at his death, the remaining part of what is left that he does not want for his own wants, and that was held to not be sufficiently certain. So in this case, the testatrix provided that property would be left to her husband to use absolutely, but that the remaining part of what is left that he does not want for his own wants and use was to be held on a defined trust. It was held that this statement was too uncertain for the trust to take effect over any part of the property because the property was not sufficiently clearly identifiable by the expression the remaining part of what is left. Parma and Simmons and In this case, a testatrix left the bulk of her estate on certain trusts, and it was held that the subject matter of this trust was too uncertain by dint of the vagueness of the expression the bulk. However, a trust of all of the residue of an estate, the remaining property when all debts have been paid, money owed called in, tax paid, and specific bequests made, will not fall or not fail for uncertainty of subjects. So a lot of people do get confused about this. A remainder or residue of an estate is sufficiently certain. In fact, all properly drafted wills will have a bequest of the residue, and that may be in the form of a trust, and in fact it commonly is. So this will not fail for certainty of its subjects, even though nobody knows how much money that is. Until the will is administered, nobody knows how much money will be left at the end, partly because we don't actually know when we're going to die most of the time. So yeah, that's that one. Regole's Wills Trust. So in this case, it was held that a provision that a reasonable income be provided out of a fund could be held to be valid if one could make an objective measurement of what would constitute a reasonable income in any particular case. So although leaving reasonable income does seem quite vague and uncertain, the court held it was sufficiently certain. They did this partly because if they didn't do so, English law would actually just fall apart. The court always talk about things being reasonable. You know, you've got the reasonable man or reasonable force, where they have accepted it as a valid and certain meaning. If they called this into dispute, if they called the word reasonableness into dispute, then it would call into dispute every other use of the word reasonable in English law. So in England, we do know what is and what is not reasonable. In other cases, the uncertainty arises from other considerations, usually when it is not possible to say which property is the subject matter of the trust. So we got this case of Boyce and Boyce from 1849, and in this case, the testator devised all my houses. So the testator left freehold houses on trust for the benefit of his wife during her lifetime, and thereafter, whichever house she chose to his daughter Maria, with the other freehold property being left to another daughter, Charlotte. So, in the case, the testator devised all my houses, and this was probably two, but the report is pretty ambiguous actually on the point, but on trust to convey one to his eldest daughter Maria, of which she could select whichever house she wanted, and the other house would go to the other daughter Charlotte. And Maria actually predeceased her mother, with the result that she was unable to make her choice. So Maria died before her mother without making a choice as to which house she wanted to have. And the court held that the bequest failed as it could not be said what property was covered by the bequest. So the court held that the gift to Charlotte failed since there could be no certainty as to which house should be held on trust for her. Both properties were therefore held on resulting trust for the testator's heirs, his grandson. So that is it for this video. That gives you a good sort of introduction to how the court have interpreted different sort of scenarios involving certainty of subject matter. In the next video, we're going to look at a few more cases, but looking at a very specific type of situation, and that's trust of bulk or interchangeable property. So we're going to look at cases such as London Wine Co. and Gold Court Exchange. So that will be coming up next time. But if you have any questions about this video, please leave a comment below and I'll get straight back to you. And don't forget to like this video and subscribe to my channel. Thank you very much for watching.